Hello, I'm Commissioner Carolina Mejia, and today I'm having coffee with Judge Brett Buckley. Judge Buckley is the presiding judge for Thurston County District Court, and I'm really happy that you're here with me today.
Commissioner Mejia, my pleasure. Glad to get you back to the main campus where you grew up as a commissioner.
Well, I'm having coffee, you're having water. We had a discussion on you don't do coffee, but I'm very excited to be here in District Court, and there's a lot of exciting things happening. It's been a hectic, is that the correct word, past 2 years with the pandemic, and the court has had to readapt completely, and so I wanted to have a discussion with you. I know there's a lot of new and exciting things happening at District Court, a lot of new pilot programs that have launched, and I was hoping that you could talk to me a little bit about those today.
Sure. Well, let's start with the pandemic. That changed everything for all of us, no matter what we do. Here at court, of course, as soon as it happened, and we understood how serious it was, we actually had to close the court. And that, of course, raised the concern about, well, people need access to a court for all sorts of reasons. And we then opened up the court, but without allowing people here. And we had to come up with a way to do that. And like many courts around the country, we figured out how to conduct virtual hearings, which in fact was something we had wanted to do for years and years. I have always been an advocate of making court proceedings really transparent. I really had wanted to live stream court proceedings, and we'd never been able to figure it out. And then necessity led to creativity, and we figured out how to get on Zoom and how to get on YouTube. And we had to be on YouTube because when you conduct a court proceeding, the public has the absolute constitutional right to be present. But if the court doors are locked, they can't be present. So in order for them to be present, we had to stream our proceedings so that they could access them, and we use YouTube as the platform for that, and it's something we will never change. We are not going back, and we really pride ourselves on the fact that all of our court proceedings are live streamed, and if anybody wanted to find out anything about the court or the participants or the cases, all they need to do is go to the district court website, see the YouTube addresses, and watch what goes on. And I think that's a big step forward for us.
I think so too, and that was going to be my question is, not that the pandemic numbers have gone down and we're seeing everything kind of reopen. Is district court planning, and you said no, you're planning to still keep that accessibility point open through YouTube and through other live streaming platforms, I guess. Zoom, I'm guessing, is the platform that you're using.
Yes.
It's the platform that all of us are using. So, but
Be nice to have some stock in that company, wouldn't it?
Right. I wanted to. I remember when we did The Color of Justice a couple of years ago, many years ago, actually. There was a lot of questions of like, well, what does district court do, and what's the difference between district court and superior court? And so I'm going to ask you that question because I think there's a lot of questions sometimes in the community. I'm like, should I go to district court for this, or should I go to superior court? And you as a judge, I'm hoping you can tell me the main umbrella that district court covers.
I think the easiest way to start off would be to say district court is where most people end up going to court. If they have to go to court or want to go to court, it's usually going to be district court. Now, we are a misdemeanor level court, so that means if you're charged with a crime that's not a felony, you're going to be in district court unless you're in one of the city's municipal courts, although we are the municipal court for the city of Lacey, for the city of Rainier, and the city of Tumwater. So the county handles those courts as well, and that's all part of what we do here at district court. We also have civil calendars, so we do protection orders. That's a big part of what we do. We have civil cases. We do small claims cases. We have civil cases where there are frequently attorneys involved. We do name changes. A lot of the routine things that people might have contact with the court for. So those are the types of things we do. So we treat or see many more people than, say, Superior Court. Their cases are more serious. They involve very specific parties, and they tend to go longer, whereas here in District Court, volume is really the dominating force that exists on our caseload, and how we really have to work to make sure that we don't get overwhelmed by the volume. We can handle it, but we have to come up with ways that allow us to hear each case that needs to be heard. And that's where the virtual hearings have really helped out.
Oh, that's wonderful. So your scope is pretty large and well, you know, and volume. So let's talk about volume in the sense of, I guess I'll touch back on the pandemic, just because that's kind of ruled over our lives for the past 2 years. But there's, you know, we heard a lot about this, the court backlog, and just kind of how did that affect district court, especially when it comes to volume?
It hasn't helped. As I said initially, we had to stop all activity, you know, as public health officers, and everybody else is trying to figure out what could we do safely. And for a while, we were all afraid to be around any other human being, and we had to sort of sort through that. And when we were in that stage, cases were occurring, things were happening, arrests were being made, but we couldn't process them because we didn't know what could be done safely. Once we opened up the courthouse, both virtually and then eventually in person, we began to process cases, but it's much slower. People were still a little bit leery about how to connect with each other and trying to figure out the access. It took a long time for people to get used to the virtual hearings and how to participate in those, although I would say by now most people are pretty good at it, and access doesn't seem to have been a major obstacle for virtual hearings. But it did create a whole series of cases that weren't being addressed, and so our backlog, we took the approach of let's not forget those old cases, those cases that were left over from 2019, right as we hit 2020 and the pandemic starting. They weren't right. We couldn't take them to jury trial, the cases that weren't going to be resolved short of jury trial. I don't think we started juries until well into 2020, so you could see there's a whole time period there where we couldn't get a case to its final conclusion if it wasn't going to be otherwise resolved. So they all went into a backlog. Then we started trials, and then the pandemic flared up again. We had to stop. And the reason we couldn't have trials is because the courtrooms we have here in this building are quite small, and it just we couldn't do the proper social distancing in there, and you know we had airflow issues, so we couldn't keep the parties safe. We couldn't keep the jurors, the citizens who were asking to come in and you know be jurors. We couldn't tell them that we thought it was going to be safe for them. The county eventually leased space for us in another building, a much larger room, and so we were able to open up trials. But over the fits and starts of that period of time, a lot of cases weren't going to trial, and they just fell into this backlog. And unfortunately, it's sort of human nature that people want to do the work that appears in front of them. So as cases never stopped coming in. So the lawyers kept prepping the cases that were just coming in across their desk, and this backlog continues to exist. And so we took the approach of saying we will give priority to the oldest cases and then try to move forward, trying to encourage everybody to start there and work on the backlog that way and not just forget those cases.
Thank you. Well, let's get to the meat and potatoes of why we're actually here. And I've kind of deviated and asked you about a couple of other things, but you launched a very exciting project this year having to do with conditions of release, specifically for in regards to substance abuse. So can Can you talk a little bit about that?
Sure. Well, because you and I have had many conversations about this prior to us starting it, and we've had this technology device that has been available to us. It's we call it a transdermal alcohol monitoring device. We just made up that name, so we weren't using trade names, but the primary trade name is SCRAM, so I'll just say that because that's what people know it as. And it's a device that a court may require you to have, and it's usually worn around the ankle, and it measures your perspiration, and in checking your perspiration, it can determine the alcohol content of that perspiration, and that lets us know whether you've been consuming alcohol. And you wear it 24 hours a day, 7 days a week, until the court says you can take it off. So we have some idea of whether somebody is consuming alcohol. It doesn't measure for any other drugs, because the other drugs aren't readily apparent in the perspiration of somebody's skin. But it does allow us to monitor the alcohol use. However, the problem with that technology is that it's quite expensive. So it can run up to $15 to $20 a day. And so when you're asking folks who don't have much income, you're not asking them, you're telling them, I won't put you in jail, but you need this monitor because I'm concerned about your potential use of alcohol. That can be a major obstacle for them financially. And that may mean that if they can't afford the SCRAM, then they're going to stay in jail. And that doesn't seem really fair. And we've talked about this, that folks who could afford it aren't going to go to jail. But folks who couldn't afford it will probably have to stay in jail because we didn't have any other really good way of making sure that they weren't consuming alcohol. And this applies, of course, to folks where alcohol was a significant contributor to the crime they committed. Most obviously DUIs.
Okay.
But not just DUIs, also domestic violence cases. There are numerous domestic violence cases where alcohol use or abuse is a significant issue in the relationship and was a significant factor in the, say, for example, domestic violence assault that occurred that has them before the court. And we would order them not to use alcohol, but we needed to make sure we had a way to monitor that. We want to trust, but we want to verify. So we needed some testing mechanism. That technology allows it, but if they can't afford it, do we tell all those people, sorry, you're going to stay in jail? And being in jail during a pandemic was a really tough place to be. You didn't want these congregate settings where there were a lot of people. You had no idea their health status, and it just made things really tough for the corrections officers. It made things tough for the incarcerated folks. So we really wanted to keep an open mind about how not to put people in jail, but try to safely monitor them. And that's why we kept requesting that the county get involved in helping fund this monitoring program. And after a lot of discussion, the county agreed to, and we actually got approval from the county at the end of 2021 for a test project in this area. And we started, after working on contracts, we signed a contract with Friendship Diversion Services and started in May of this year. And we have provided these monitoring devices. Let's see, it looks like, let me put on my glasses and I'll tell you. Through the end of October, we have 117 people wearing monitoring devices.
Wow.
Through the county program. And that's probably 117 people who, would all of them have been in jail? Maybe not all of them, but a high percentage of them, because they warranted the need for this intensive alcohol monitoring, but those folks couldn't afford it. So that's an important number to know, because jail costs are $120, $125, maybe even more a day, maybe even up to $150 a day, depending on the need of the person.
Yeah.
And if the SCRAM device, which commercially is available at $15 to $20 a day, but the county is getting it through Friendship Diversion at somewhat less, there's a huge savings. for those 117 people, for every day that we're monitoring them, that's a lot of money that the county ultimately is saving in incarceration costs, as opposed to the cost of providing scram to indigent folks who otherwise wouldn't have this device. And the money that the commissioners appropriated also helps us go to providing urinalysis at no cost to defendants who can't otherwise afford it. And that's important because using those resources, we're able to test people for whom alcohol is not the issue. It may be methamphetamine, it may be opioid abuse, and we can then require them to do some testing there that they otherwise couldn't afford to pay for.
Okay, thank you for that. And we've had, of course, many conversations about this, and it was definitely just a great thing to advocate for. We were able to do this out of the American Rescue Plan Act funding we got from the federal government, and of course we decided to do a one-year pilot project to see how well this program was going to work. Of course, District Court had the numbers, and you were telling the commissioners, this is going to work. This is the numbers that we estimated, and they were pretty spot on from the numbers that you're even stating now. And it's pretty great to see, kind of the impact that it's having, really, not only in our jail system, as well as, we have a full jail, and of course there's staffing shortages, and I feel like that adds up, every time there's an overtime cost for correction staff. So going back to the substance monitoring program, can we talk about, when someone gets a DUI, for example, what is the typical condition of release?
When somebody gets a DUI, first thing we do is we look at their record. If this is their first DUI, if it's not a very large alcohol number, their conditions of release are just going to be don't drink, don't drive unless you have a license and insurance, don't go into bars or taverns. And then they're going to walk out of the courtroom. They're not going to go to jail on a first DUI almost all of the time. If they have prior history of driving under the influence, the number of priors, the time difference between their last DUI and their current DUI, those sorts of things will be factors that the judge will look at in determining how intensive the monitoring needs to be. The law does require that at the very least, if they've had a prior DUI, the person's going to have what's called an ignition interlock device, which is a device that you have to have in your car, which forces you to blow into the device and see if you have any alcohol on your breath, and the car won't start if you do. And then you have to periodically pull over and blow as you're driving. And that's a state requirement by state statute. However, we supplement that frequently with the scram device because if somebody decides, well, fine, I'm not going to drive, but I'm still going to drink, well, drinking may lead to some other problems, or they may drive a car that doesn't have the ignition interlock device. So we want to know if they're drinking, and then if we combine the ignition interlock with the scram, then we have pretty good safety net there from a technology standpoint. So the scram device is important in that way, and it's allowed us, just in very general terms here, to say that if somebody has one prior, we would probably use a scram device and not put them in jail prior to prior to the pandemic. Now, if they have two priors and they're somewhat dated, we still feel fairly comfortable in putting them on a scram device with the ignition interlock and having a high degree of confidence that we are not threatening public safety by not holding them in jail. But it's also allowed us to reduce the jail costs for that group of that population. Now, if they have a serious DUI history, they're probably going to go to jail, and it's going to take a lot to get them out of jail on a scram device with that type of history. But it's allowed us to expand the group of people where we can be a bit more flexible, not incarcerate them, keep the public safe, and make sure that these folks aren't drinking and aren't getting behind the wheel of a car having had alcohol.
So you've mentioned a couple of benefits to the individual who is going through the process. Can you mention other benefits to the individual as well as to the community as a whole? And I think you've touched on some, from public safety to jail savings. Are there other benefits to this program, to both the individual going and to the community as a whole?
Well, community as a whole, what you just summed up is correct. I think it really enhances public safety because we have good monitoring on folks. If we're monitoring them 24/7, then that's as good as you can get. And people may be saying, well, how do you do it? It goes in through this. We signed a contract with an organization called Friendship Diversion. They receive the data from these devices, and if there's any indication of use, they then forward that data to the court, and then we summons that person into court, and we're going to have a conversation. And they may end up, in fact, going to jail as a result of that use, or we may make some other decision. But we know, and we can get these people into court pretty quickly based on that. So public safety, I think, is greatly enhanced by the use of these devices. The cost to the public is reduced because we use these devices and we don't incarcerate a group of people who, for the most part, when are on scram, are very compliant. In fact, our numbers show that we're getting even a little less than 1% of the people who are on scram are testing positive for alcohol use. So that's a very small number, and we get them into court and deal with that pretty quickly. So I feel quite confident that we've hit the right population where we can keep them out of jail. They otherwise might have been there, but we can also let the public know we're doing our best to keep them safe from these folks who have had a propensity for drinking and driving. Beyond that, let's look at the person who's in that situation. I have had a number of folks tell me after I'm ordered the scram device, and maybe it's been on for 30 days or 60 days or some period of time pre-trial, and they may object at first, but when they finish it, when I sign the order which says you can take the scram device off, I'll say, so okay, so give me your thoughts about that scram device and what was the impact on you? And they say, many times I've heard them say, my gosh, I hated the device, but I love the result because it reminded me every moment of every day that I can't drink. And I probably would have if I didn't have that reminder. And so a number of people have really been quite thankful for the fact that we've ordered that device. And that number has increased as the county has started to pay for that device. So for a lot of people, it was just that financial commitment, and it was just draining their resources. And so even though it was of benefit to them, they also felt the great stress of being out a lot of money.
Can I ask how much before the county started, how much would people have to pay for it? Was it on a monthly basis, weekly basis, daily basis that they had to pay a certain amount?
Yeah, it's generally, I think the market generally was about a $50 installation fee for the device, and then up to $20 a day.
Oh, wow.
A day.
So if you're...
So that's, roughly $600 a month, a little bit more. And if the device is going to be on for, let's say, the speedy trial time of a case of 90 days, that's 3 months, that's $2,000 just to have your monitoring device.
Yeah.
And that's a big expense. And so even if it's serving the purpose of encouraging you not to use, you're also developing a significant financial problem. And so you may not see the benefit of the device because you just are so stressed about where you are financially. So that's what the county has done. By allowing us to send people to get these devices, and they don't have to worry about the financial impact, it allows them to really focus on the problem we're trying to address, which is their abuse of alcohol.
Yes, and still providing that accountability. I think that community, I know usually that's the word that comes up, is the accountability part. And just in conversations and through the process they have to go through that, I think Scram is able to provide that, right? They have to keep clean for a certain amount of period of time what they have the device on, and hopefully helps them on to better themselves. And with that, I'm going to ask you, is there any story that sticks out to you about the role that that Scram has had that you would like to share with us today?
Sure. Even though we've only been on the county-funded Scram since May, we actually have been using public funds to support Scram in our 2 treatment courts here in District Court. So District Court is also the home to the county's mental health court and the county's veterans court. And using funds through the treatment sales tax, we've been providing Scram devices to participants in those courts when we see them move away from their positive treatment responses and maybe relapse and go back into drinking. We'll put them on a Scram device. And we've been doing this for years. And so we have a lot of history of seeing the positive impacts of that. And so not having to lock them up and say, okay, we have this resource through the treatment sales tax where we can pay for the Scram, but you are going to wear the Scram. Sometimes I'll say wear it for 2 weeks, and the 2 weeks totally changes everything for them. They get that reminder. Okay, I have a responsibility, a personal responsibility not to consume. I have this accountability that you just referred to, where I'm being measured, and they just reset their mind about the use and their daily habits. And I can take it off after 2 weeks, and then we continue to UA them afterwards, and we don't run into a problem. I've seen that time and again. Sometimes it's just enough of a reminder of what the appropriate behavior is that it serves that purpose. And then anecdotally, we've had a number of people, as I said earlier, who say, thank you for making me wear this thing. It has really kept me from falling off the deep end, because I really wanted to drink, but I knew I couldn't. I'd get caught if I did, and so I didn't. So
I'm going to ask I know this has only been going to May, but have you noticed a percentage in the, I guess would be recidivism or the failure rate? I'm not specifically sure what you would call it, but have you noticed before, when people were paying for it, was there less compliance, I guess would be the word, or is there more compliance? What kind of like the before and after? Have you noticed a difference in any of that?
Huge difference, because we would see many of these cases where we ordered Scram appear back before us, not because the person has violated showing positive for alcohol, but because they're coming in and they've had to turn their device back in because they stopped paying for it. So we were the financial review of these devices and the impact of these devices was causing us to have to come up with solutions about what do we do now. They just can't pay for it. They had it, it was fine, they weren't drinking on it, but now the provider of the device says they're not paying, and so they cut it off their ankle. We don't have those hearings anymore, and they were pretty frequent. So in district court, we provide public counsel to about 80 to 85% of the people we have on our criminal calendars. Those folks have some level of indigency. That means that they are financially stressed. And when we're ordering Scram for folks, it's that same population. We're not talking, generally speaking, about a population that has much money. So this thing can just be a real financial burden for folks. Yeah. And so we were having lots of hearings on that. And that it just seems silly to us that we were having so many hearings, which is one of the reasons we kept saying, if we could only get the county to pay for the Scram, then we wouldn't have to have these hearings, and we would keep these people out of jail, but being effectively monitored. And we kept encouraging defense counsel, hey, please talk to the county commissioners and say, my clients are always telling us how expensive scram is and how they don't have the money for it. And if they could only get scram that they didn't have to pay for, then we could keep them out of jail. And that was the argument we were, making all along. And it seems to be bearing fruit through the first, 7 months of this program. Well,
I guess from the board side of things, it's very exciting to hear this. I know that we're going to be revising as the ARPA conversations come back, or the American Rescue Relief Fund comes up, conversations come up on funding. But thank you again for joining me today and really discussing the programs that District Court is doing, how you've adapted through the pandemic. It really has been a pleasure, Judge Buckley. This really has truly been a great conversation for everyone watching. If you want to keep up with your local government, subscribe to the county's YouTube channel. You can watch the Board of County Commissioners meetings, work sessions, and shows like this on there. Thank you so much, Judge Buckley. It was a pleasure to have you on here.